You should help the potentially close control your classrooms. Don't you have recording it? Please try. Mistake is one of those contractual phenomena. One of those contractual phenomena which phenomena, 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 which are responsible for vitiating a contract. Full stop. The consequence of a vitiating mistake, the consequence of vitiating mistake in a contract is that the contract mistake in a contract is that, come on, the contract is treated to be void ab initio, to be void ab initio, void ab initio. Void ab initio. Come on. Meaning void from the very beginning. Void from the very beginning. Full stop. Next paragraph. Unlike misrepresentation, a mistake renders a contract void. Hence, if a mistake operates in a contract which is required to transfer title / ownership, title / ownership / proprietary interest in properties, such transfer attempt fails. Such transfer attempt fails as a void contract being not a contract, cannot pass any proprietary interest whatsoever. Any proprietary interest whatsoever. Any proprietary interest whatsoever. Full stop. Next paragraph. Not all contractual mistakes are, however, responsible for vitiating the contract. Not responsible for vitiating the contract. Full stop. Only the ones which are recognized in law. Only the ones which are recognized in law. Only the ones which are recognized in law shall do so. Good stop. The following categorization might help to understand the scope of operative mistakes. Operative mistakes. Full stop. Next paragraph. In broad terms, mistakes will generally be either bilateral or unilateral. First, a mistake is a bilateral one where both of the parties will be found to be laboring under mistaken assumptions. Laboring under mistaken assumptions. Full stop. A unilateral mistake, on the other hand, refers to a mistake which is refers to a mistake which is borne by only one part to the contract. Beer, borne. Borne by only one part. And the other party essentially is well aware of the first party's mistake. well aware of the first party's mistake. So, next paragraph. Further, a bilateral mistake can be divided into two categories. First one, a common mistake. A common mistake. A common mistake. And a cross-purposes mistake. A common mistake may arise when both of the parties are laboring under a common mistaken assumption. Mistaken assumption. Whereas a cross-purposes mistake will appear when the parties will be at cross purposes. Will be at cross purposes. And their mistakes will relate to two different sets of facts. Two different sets of two different sets of facts. First off, take it in. Right. That's next paragraph. Unilateral mistakes. Unilateral mistakes may either relate to a term of the contract or to the identity of a contracting party. Full stop. If such a mistake relates to a third factor, such a mistake is not recognizable in law. Such a mistake is not recognizable in law. Full stop. Now listen to me carefully. We have to go to the summary of what we have done in the last class. Mistake consequence. Mistake renders the contract void, and mistake renders the contract void. Then we identified what is the difference between the void and the void of the contract. And then we have practically seen what will be the consequence if a contract is void and not voidable. Right? Misrepresentation of mistake jodi after overlapping condition থাকে তাহলে আপনার কোনটাতে কি advantage এবং disadvantage হতে পারে সে ব্যাপারে we have started to develop some understanding. তারপরে আমরা দেখেছি যে mistake is a vitiating factor which renders a contract void. একটা প্রশ্ন হচ্ছে যে মিস্টেকটা যে কোনো mistake কি contract void করে কিনা? The answer is no. Only the recognizable mistakes do that. And what are the recognizable mistakes? We went into the categorizations of mistake. After the mistake has been categorized into two categories: bilateral and unilateral. Bilateral mistake is where both of the parties are mistaken. Unilateral mistake is where only one part is mistaken and the other knows about the first party's mistake. Bilateral mistake are of two types: common mistake and cross-purpose mistake. Common mistake is where both of the parties are mistaken as to a common set of facts. Cross-purpose mistake, which both of the parties are mistaken as to a separate set of facts. In body of unilateral mistake has been further divided into two categories. One is it must either relate to a term of the contract or it must relate to the identity of the contract. But if it relates to neither, then it is not a unilateral mistake at all, a recognizable mistake at all. Give me a second, please. Sorry. That's right. So we will be starting with common mistake. Listen. What is a common mistake? A common mistake is, as you already understand, where both of the parties are mistaken as to a common set of facts, or they are mistaken, laboring under a common mistaken assumption. The example that we have given in the last class was this. The two parties have entered into a contract for letting out of a flat. Now, the flat which has been letted out, the flat which has been rented out, is something before the agreement has been reached was demolished, unknown to both of the parties. So what is happening is that party X, who is renting it out, and the party Y, who is receiving the lease, both of them are laboring under a common mistaken assumption that a flat exists. However, the flat does not exist. So it is what? A common mistake. This will render the contract void. Can the subject matter is absent. Kobe absent? যখন আমরা contract করছি তখন। কেন তাহলে এটা void হচ্ছে? Because দুই party were mistaken as to what? As to the existence of the subject matter of the contract. Do you get it? ঠিক আছে? এটাকে আমরা বলছি একটা common mistake, right? এখন common mistake অনেক তো প্যাটার্নের হতে পারে, সেই প্যাটার্নস গুলো আমরা এক্সপ্লেইন করব। We will try to get into this in a number of ways. ধরেন আমি আরেকটা এক্সাম্পল দিচ্ছি, এরকম করব। Let's say I have entered into a contract with you for the purchase of some goods. ঠিক আছে? And what are the goods that I am purchasing from you? I have purchased from you some goods which are now being ported by a ship in the deep sea. ঠিক আছে? গুডস গুলো পোর্টেড হয়ে আসছে, জার্মানি থেকে রওনা দিয়েছে, এখন সমুদ্রের মাঝখানে আছে, এটা এসে পৌঁছবে, সেটা যখন পোর্টে রিলিজড হবে, তারপরে আমি আপনার কাছে গুডসগুলো ডেলিভার পাবো। কিন্তু আমি এখন অলরেডি আপনার সাথে একটা কন্ট্রাক্ট করে ফেললাম যে ওই জাহাজের ওই কার্গোতে অত নাম্বার লটে যে আইটেমস গুলো আছে সেগুলো আমি আপনার কাছ থেকে কিনে নিলাম। right? So a contract has been entered into. কবে আমরা কন্ট্রাক্ট করেছি? 20 তারিখে কন্ট্রাক্ট করেছি। 19 তারিখে রাত্রে বেলা the ship sank. Yes, the day before the contract. 19 তারিখে রাত্রে বেলা শিপ ডুবে গেছে, আমরা কেউ জানি না, আমরা খবর পেয়েছি 21 তারিখে। কন্ট্রাক্ট করেছি কবে? 20 তারিখে। 19 তারিখে ডুবে গেছে। তাহলে the goods have perished on the 19th. So when on the 20th we are entering into a contract for the purchase of the goods no longer exist. So both of us at the time of entering into the contract are laboring under a mistaken assumption that the goods exist. কাজেই এটাকে আমরা বলবো as a common mistake which will render the contract right. Yes, which will render the contract void. So as if no contract has ever been made regarding that. আপনি বলেন after contract কি হবে? কি হবে?
Sorry, yeah, first
কেন? কন্ট্রাক্ট ফ্রাস্ট্রেটেড হওয়ার জন্য আগে তাকে কন্ট্রাক্ট হতে হবে, রাইট? কন্ট্রাক্ট হবে তারপরে তো ফ্রাস্ট্রেশন হবে। যেখানে কমন মিস্টেক হয়ে কন্ট্রাক্ট ভয়েড হয়ে যায় সেখানে ফ্রাস্ট্রেশন আসবে কোথা থেকে? ভয়েড মানে কি? ভয়েড অফ ইনিশিয়াল, ভয়েড ফ্রম দ্য ভেরি বিগিনিং। আর যেটা ভয়েড ফ্রম দ্য ভেরি বিগিনিং তার মানে কি? সেই কন্ট্রাক্ট কখনো তৈরি হয়নি। যে কন্ট্রাক্ট তৈরি হয়নি সে ফ্রাস্ট্রেটেড হয় কি করে? ঠিক আছে, আচ্ছা, যদি কন্ট্রাক্টের পরে যদি সেটা ডুবে যায় তাহলে ফ্রাস্ট্রেটেড হলেও হতে পারে। ঠিক আছে, ফ্রাস্ট্রেশন আপনাদের পড়া হয়েছে? আচ্ছা, রাইট, কার বলছে না? আমি জানতে চাচ্ছি ক্লাসে পড়ানো হয়েছে কিনা। আচ্ছা, রাইট, আচ্ছা, এখন right. The first case that we will look into, as far as common mistake is concerned, is the most important authority in the whole chapter of mistake. But at the same time, the case by its facts, because of its decisions, are a little complicated. You need to try and understand the particular anomalies arising out of the decision of the case. The case is Bell versus Lever Brothers. Are you familiar with the name? No. Canada? Canada? Tutorial highly? Bell versus Lever Brothers. You can say, sure. What does Bell versus Lever Brothers tells us? What does that tells us? Shouldn't I should before you write? Bell versus Lever Brothers talks about definitely common mistake, but before Bell versus Lever Brothers, what we knew is that any mistake which is recognizable in law will render a contract void, right? Right. Bell versus Lever Brothers is the first case which is saying, listen carefully, that a common mistake will only render a contract void if it is a sufficiently fundamental mistake. So what do we gather from here? We gather from here that not all common mistakes, again, not all common mistakes will render a contract void. So which common mistakes will render a contract void? Only those common mistakes which are sufficiently fundamental, right? He's right. According to the House of Lords in Bell versus Lever Brothers, Bell versus Lever Brothers. only a sufficiently fundamental common mistake. Only a sufficiently fundamental common mistake may render a contract void. May render a contract void. Full stop. Now listen. Sufficiently fundamental mistake may render a contract void. তাই না? তাহলে প্রশ্ন হচ্ছে যে কতগুলো sufficiently fundamental mistake will any common mistake render a contract void? No. Only those mistakes which are sufficiently fundamental. Only those common mistakes which are sufficiently fundamental will render a contract void. Now the question is, what do we basically mean by a sufficiently fundamental mistake, right? That needs to be defined. In the same case, they have provided us with the definition, right? Please write the definition. They can load 8K. Load 8K. ATKIN. Load 8K. And load Tankerton. THANKERTON. Lord Tankerton in Bell versus Liver Brothers. Defined common mistake. Sorry. Defined a sufficiently fundamental mistake. To be a mistake which relates to something. Which relates to something. Which both of the parties to the contract yes, both of the parties to the contract must have necessarily accepted as an essential element of the subject matter of the contract. Must have necessarily accepted as an essential element of the subject matter of the contract. Right? So key definition needs to sufficiently fundamental mistake. The first thing that we get to know from Bell versus Liver Brothers is that not all common mistakes can render a contract void. Only those common mistakes can, which are sufficiently fundamental. So the next question is, what is a sufficiently fundamental mistake? Put it in keyboard say that. Both say age of the high contracts. Age of the high contract is subject matter. Is subject matter in age of the high essential elements. To get it. Contracts, subject matter of it, and subject matter is essential elements of happiness from A to I. And if your mistake relates to one of these essential elements, it is a sufficiently fundamental mistake. Now, how do
If I have a car and I want a particular color for that car, that's the
Essential.
if you want to buy a car, the subject matter of the contract is the car.
no. Was it that it has to be a white car?
Maybe it's a sufficiently fundamental mistake because this is an essential element. Now the question is, how do we determine whether something is an essential element of subject matter? When both of the parties have accepted it to be an essential element. For it, you read it. Your mistake must relate to something which both of the parties must have necessarily accepted, keep as an essential element of the subject matter of the contract. Now, how do we actually determine that in a given situation is actually a little bit of troublesome matter. Whether the parties have agreed this to be a sufficiently fundamental mistake, whether the parties have accepted this to be an essential element of the subject matter of the contract or not. Okay, so we'll go to that. Let us theoretically first try to understand what it meant. This meant for every contract, there will have to be a subject matter. In every subject matter, there will be certain essential elements. And your mistake must relate to an essential element of the subject matter of the contract. Now, our test is, what is the contract? What is its subject matter? What are the essential elements? Does my mistake relate to an essential element? If so, then it is a sufficiently fundamental mistake. If not, it is not. Right. Now, let us first talk about the facts of Bell versus Liver Brothers. This is something that's very important. You need to understand every bit of it. Please pay due attention, everybody. Everybody is in half sleep. Due to your lunch before you come to my class. That's better.
Thank you, sir.
Right, sir. Bell versus Liver Brothers equation. Liver Brothers Company in 1931, they were going through a major reorganizing process, major reshuffling process. Tara কিছু company renovation এর কাজ করবে, company-কে restructure করবে, group of companies তৈরি করবে, multinational business এ যাবে, নানা রকম new ventures are being accommodated into the company. So they thought that their old staff and old employees are not really accommodative towards the changes that they are focusing upon. So তাদের দুটো পুরনো বিশ্বস্ত managers ছিল, they wanted to give golden handshakes to. You know what it is? I give you a good amount of money, you quit the job without troubling us. So these two managers were known as Mr. Bell and Mr. Snelling, two managers. Bell and Snelling. এই দুজনকে তারা কোম্পানি থেকে বিদায় করে দিবে। So how did they plan to do that? They will pay a good compensation package to them, and they will quit the job without troubling the company. So তাই করা হয়েছে। Mr. Bell has entered into a compensation agreement with the company. Company তাকে compensation দিল, Mr. Bell বলল ওকে আমি জব ছেড়ে দিচ্ছি বলে চলে গেল। ঠিক স্নেলিং কেও তারা একই অ্যামাউন্টের টাকা দিল, স্নেলিং জব ছেড়ে দিয়ে চলে গেল। তখনকার দিনে 1930s they were given a huge amount of money. দুজন মিলে প্রায় 35,000 pounds. And the বিষয়টা আমি বলবো huge amount of money, 1935. যাই হোক, so as they have taken them out, so they went home. They're enjoying their property, holidays, etc. Right. এবার লিভার ব্রাদার্স কোম্পানি যখন তাদের রিঅর্গানাইজিংটা শেষ হয়েছে, তখন they realized that what they did was a mistake. তারা দেখলো এই Mr. Bell and Mr. Snelling, when they served in the company, they for a number of times bridged their duties and obligations. So they could have been sacked from the company without being compensated. বুঝতে পারছেন? যাকে এমনি তাড়িয়ে দেয়া যায় তাকে আপনি কম্পেনসেশন দিয়ে তাড়িয়েছেন। You get it? বুঝতে পারছেন? মনোযোগ দিয়ে শুনে প্লিজ, এরপর এই কথা যদি পরে আবার কেউ বলবেও না, বোঝাবেও না, নিজেরাও বুঝবে না। রাইট। সো কি হয়েছে, তাকে কম্পেনসেশন দিয়ে তাড়িয়েছে। সো দে আইডেন্টিফাইড দেয়ার ইজ আ মিস্টেক। এবার তারা বেল এন্ড স্টেলিং এর বিরুদ্ধে মামলা করেছে। মামলা করে বলছে আপনাদের টাকা ফেরত দাও। On what basis? তারা বলছে the compensation agreements that we entered with you were void for a common mistake. And since they were common mistakes, the contracts were void. আর কন্ট্রাক্ট যদি void হয়ে থাকে, যেটা আমরা তোমাকে দিয়েছি সেই টাকার ওনারশিপ তোমাদের কাছে পাস করে নাই, we are still the owners of the money. So give us our money back. Do you get it? বুঝতে পারছেন কি বলছি? রাইট। এই পর্যন্ত আমরা কথা বুঝতে পারছেন তো? রাইট। কোর্টের ডিসিশন কি সেটা আমরা পরে শুনবো। আগে একটা ইন্টারেস্টিং ব্যাপার বলেন আমাকে। কোর্ট বলছে yes, it is a case of common mistake. আমাকে বোঝান তো এটা কমন মিস্টেক হয় কি করে? কমন মিস্টেক হতে গেলে there will have to be both parties under a mistaken assumption. এখানে দুই পার্টি মিস্টেক করেছে। দুই পার্টি কারা? একদিকে লিভার ব্রাদার্স, আরেকদিকে বেল। দুজনের মিস্টেক আছে এখানে। মিস্টেক যদি হয়ে থাকে তাহলে কে? Lever Brothers may be mistaken. Is Bell mistaken? Lever Brothers, Lever Brothers thought that Bell was entitled to compensation. Actually, Bell was not entitled to compensation. So, Lever Brothers may be mistaken as to Bell's entitlement to compensation. But can Bell himself be mistaken about his entitlement to compensation?
Yes. He knew they could have sacked him. He knew that he did not deserve it, or they could have sacked him.
And was he mistaken?
Yes. No, he knew that. He knew he was right. He was not mistaken.
Then how come was he mistaken? কথাটা বুঝতে পারছেন? আমি কি বলছি বুঝতে পারছেন? The first thing that the court identified this to be a common mistake was itself a misnomer. বুঝতে পারছেন? এটা তো মিস্টেক, কমন মিস্টেকের কেসই হয় না এটা। To get the point? আচ্ছা, কেন এটা হলো সেটা আরো রাদার ইন্টারেস্টিং। শুনুন কি হয়েছে। 1935 এ তখনও সিভিল কেসে কিছু কিছু জায়গায় জুরি ট্রায়াল ওয়াজ ইফেক্ট। I'm sure জুরি ট্রায়াল আমার ব্যাখ্যা করতে হবে না। So jury trial civil case নাই, আমরা জানি criminal case আছে। Jury trial civil case এখন খুব লিমিটেড আকারে আছে, defamation and related cases। তাও jury শুধু determine করতে পারে whether there is a defamation or not, কিন্তু jury compensation determine করতে পারে না। তখন সমস্ত সিভিল কেসেস jury trial ছিল এবং jury চাইলে সবই determine করতে পারে। এখন jury একটা ব্যাপারে কনভিন্সড হয়েছে। কি শোনেন? Jury is convinced that Mr. Bell, although he bridged his duties during his service in the company, he later forgot that he has committed those breaches. Sorry?
He was forgiven.
Alzheimer থাকা দরকার নাই। ধরেন একজন একটা 30 years একটা কোম্পানিতে চাকরি করেছে। এখন সেই জুরিকে কনভিন্স করে যে দেখো 30 বছরের মধ্যে আমি প্রথম 5 বছরে কি করেছিলাম আমার তো মনে রাখা সম্ভব। Probably not. ঠিক আছে, আচ্ছা যাই হোক, জুরি গট কনভিন্সড। খেয়াল করেন, জুরি গট কনভিন্সড যে ও যে ব্রিচ অফ ডিউটিস করেছিল ও ভুলে গেছে। তার মানে he also thought that he was entitled to compensation. Do you get the point? এই পয়েন্টে কোর্ট বলছে well it's a common mistake কেন ও ভুলে গিয়েছিল সুতরাং he was mistaken that he mistakenly thought that he was entitled to compensation কোম্পানিও মনে করেছে he was entitled to compensation and দুজনের mistake have merged together that is the case of common mistake বোঝা যাচ্ছে right আচ্ছা বুঝলাম এটা common mistake এরপরে কোর্ট কি বলছে well এই common mistake থেকে কন্ট্রাক্ট void হবে না কেন 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 বলেন Canada, a mistake will render the contract void. A common mistake will render the contract void only if the common mistake is yes. It is sufficiently fundamental mistake now. It is quoted finding. What is the finding of the court? It is not a sufficiently fundamental. Yes. আমরা এবার জিজ্ঞেস করলাম কোর্টকে why is it not a sufficiently fundamental mistake? Let us try and apply the definition of sufficiently fundamental mistake which the court has itself given. Court ki bolche sufficiently fundamental mistake ki? A mistake which relates to something which both of the parties must have accepted as an essential element of the subject matter of the contract. এখন দেখেন subject matter of the contract ki? Compensation. It is an agreement. Key agreement, compensation agreement. I will give you compensation, you will quit the job. Either our mistake related kisher সাথে entitlement to compensation. Mr. Bell compensation power যোগ্যতা রাখে কি রাখে না? Eligibility to compensation. Entitlement to compensation. এটাই তো? Yes. এটার সাথে তো আমার ভুল রিলেটেড আমি ভাবছি he is not entitled sorry আমি ভাবছি mistakenly he is entitled actually he is not তাই তো so to what does my mistake relate এটা subject matter কোনটা এটা entitlement to compensation is it not an essential element of compensation বলে agreemented contracted subject matter হচ্ছে compensation and our mistake related to entitlement to compensation isn't it essentially an element of the subject matter of the contract তাই না কিন্তু court বলছে it is not an essential element of the subject matter of the contract itself which is again very surprising বুঝতে পারছেন কি বলছি right he's right. The decision of Bell vs. Lehman Brothers. The decision of Bell vs. Lehman Brothers. For a number of reasons, are capable of triggering discussion on grounds of proper determination. Full stop. First, next paragraph. Firstly, it is quite surprising that the court has identified the case to be one of common mistake. Whereas the subject matter of mistake should have been in should have been in exclusive knowledge of understand. Full stop. This, however, is a finding of jurors. This, however, is a finding of the jurors, which the court had to accept. On a factual basis. On a factual basis. Full stop. Next paragraph. However, it is further surprising. It is further surprising that the court found that the mistake in question was not sufficiently fundamental. Is not sufficiently fundamental. Although the tests of sufficiently fundamental with inverted comma, the test of sufficiently fundamental Islam. This is house number 58, Atango, on our first claim. First claim. Not both the should have to be cash. Now, up in Aba-Contratc-Bpp-Sep-Intake. আপনি আমি বলি আপনি যদি পাঠ্যক্রম থেকে পড়াটাকে মার্কেটিং সেক্ষেত্রে আপনার আপনি ওভারব্রিজটা ক্রস করছেন। হ্যাঁ, কলাবল ফার্স্টলি আমি বলি আপনাকে আপনি যদি কুপারসটা কি আপনি জানেন? কলাবল কুপারস আছে এটা। কুপারসের ঠিক ইমিডিয়েটলি আগের বলি হবে হাতের বাইরে। এক্স্যাক্টলি Sorry? What that's sufficiently fundamental. Puro sentence supported, please.
I like this point. I think that the court found a mistake in question was not sufficiently fundamental.
Although the tests of sufficiently fundamental provided by the House of Lords apparently seem to have been satisfied. Apparently seem to have been satisfied. Full stop. The commentators are of the opinion that the commentators are of the opinion that commentators are of the opinion that the court has perhaps been influenced by the fact that there was no real intention on part of Lever Brothers to sack the two employees without compensation. Right. আমরা দেখছি বেল ভার্সেস লেবার ব্রাদার্সে কি হয়েছে দেখেন, যে টেস্ট বেল ভার্সেস লেবার ব্রাদার্স দিয়ে আছে সাফিশিয়েন্টলি ফান্ডামেন্টাল মিস্টেকের, সেই টেস্ট অ্যাপ্লাই করার পরে আমাদেরকে কিন্তু রিজনেবলি অ্যাপারেন্টলি আমাদের কাছে মনে হচ্ছে টেস্ট হ্যাজ বিন স্যাটিসফাইড, বাট দ্য কোর্ট সেড দ্য টেস্ট হ্যাজ নট বিন স্যাটিসফাইড। কেন এটা কোর্ট করলো? তখন কমেন্টেটরসরা বলছেন যে perhaps the court was influenced by the fact that the real intention of Lever Brothers company was not trying to sack them without compensation. তার মানে they were so desperate, তারা যদি ওদের breach of duties সম্পর্কে জানতো, they would still have given them compensation. বুঝতে পারছি কথাটা? ওরা কি বলছে, আমরা যদি বুঝতাম যে তুমি breach of duty করেছো তাহলে তোমাকে এমনি বের করে দিতাম, কম্পেনসেশন দিতাম না। সুতরাং কম্পেনসেশন দিয়েছি কেন? বিকজ উই থট ইউ ওয়্যার এন্টাইটেলড টু কম্পেনসেশন। ঠিক আছে, দ্যাটস ওয়্যার দ্য মিস্টেক লাইজ। কমেন্টেটরসরা বলছে এটা কেসের ফ্যাক্টস পড়ে মনে হয় না, মনে হয় যে ওরা এত ডেসপারেট ছিল যে দুজনকে বিদায় করবে, ওদেরকে যা খুশি দিয়ে বিদায় করে দিত, এই কারণে ওই আমলে এত লার্জ অ্যামাউন্ট অফ মানি তাদেরকে দিয়েছে। সুতরাং তাদের রিয়েল ইন্টেনশন, দ্য রিয়েল মিস্টেক was not entitlement to compensation. বুঝতে পারছি কথাটা? Perhaps এই কারণে কোর্ট এটাকে পাত্তা দেয়নি। তবে this is something very important for you to learn, এই কেস থেকে আলটিমেট লার্নিংটা কি? Sufficiently fundamental mistake সম্পর্কে কোর্ট একটা টেস্ট দিয়েছে, রাইট? এবং সেই টেস্টটা কোর্ট নিজেই এই রকম একটা কেসে অ্যাপ্লাই করে বলছে it does not apply. তার মানে কি? The standard required to comply with this test has been said to be very high. বুঝতে পারছি? খুব সহজে sufficiently fundamental mistake হবে না। You get the point? কোর্ট কি বললো? sufficiently fundamental mistake হতে হবে। এক। দুই নাম্বার কিভাবে কি করলো? ডিফাইন করলো sufficiently fundamental mistake বলতে কি বোঝায়। তারপরে কি বললো? বললো যদিও ফ্যাক্ট দেখে মনে হচ্ছে sufficiently fundamental mistake হতে পারে, তবুও হয়নি ওই ফ্যাক্টে। আর ওই ফ্যাক্টে যদি না হয়ে থাকে তাহলে খেয়াল করেন ওই ফ্যাক্টের মতো অলমোস্ট একটা ভেরি ক্লোজ ফ্যাক্টর sufficiently fundamental mistake হচ্ছে না, তাহলে কি the test for sufficiently fundamental mistake has been said to be very high. ঠিক আছে, এখান থেকে শুরু করব নেক্সট ক্লাস। থ্যাংক
Sorry. Attendance.
Our